You open the mailbox and there it is. A violation notice from your HOA, a fine attached, and that hot flush of they can't be serious. Here's the good news most homeowners never hear. A fine is not a done deal. It's a claim the board has to back up, and there's a real, repeatable way to push back and win. So let's walk it step by step. How to read the notice, how to build your case, the defenses that actually hold up, the mistakes that sink people, and exactly when to bring in a lawyer or your state. Here's the mindset that changes everything. A fine isn't a bill you automatically owe, it's an accusation the board has to prove. Think parking ticket, not mortgage payment. Somebody has to point to the exact rule you supposedly broke, show that the rule is actually on the books, and prove the association followed its own procedure to charge you. And in a lot of states, if the board skipped the written notice or never gave you the hearing the law requires, the fine can be void before you say a single word. So when that letter lands, don't reach for your checkbook, reach for the rule book. The homeowners who lose are almost always the ones who assume the board was automatically right. Before you argue anything, you want two pieces of paper in front of you, and most people never ask for the first one. One is the specific rule, not you violated the landscaping standards, but the actual numbered provision quoted. Make them put it in writing, because vague notices are exactly where boards overreach. The second is the notice itself, and read it slowly. What they say you did when, what would fix it, and circle this, the deadline to respond. That date is the whole game. Miss it, and even a perfect defense can get tossed on a technicality. And here's a quiet lever a lot of owners miss. Most governing documents and many state laws require the HOA to have adopted a written fine policy with a fair, impartial process. If they can't show you one, the fine is standing on sand. Walk this one in order because each step sets up the next. Notice steps 1 and 2 happen before you argue at all. You're pulling the rule and the evidence together so you show up with a file, not a feeling. Step 4 is the one people skip and regret. You have to actually request that hearing in writing inside the deadline because the board will not schedule it for you. And look hard at step 6. A no from the board isn't the end of the road. It's the fork where mediation, a state complaint, or an attorney comes in. The single biggest mistake hides in the gap between steps 1 and 4, letting the clock run out while you're still deciding whether it's worth the trouble. The hearing is your one real shot, so treat it like one. In some states, the law even stacks it in your favor. Florida, for instance, sends your case to a committee of fellow owners who aren't on the board, and if that committee doesn't approve the fine, it simply cannot be imposed. Hand them a short written packet before you ever open your mouth. The notice, the rule, your photos, any approval you were given, so your argument exists on paper even if you fumble a sentence out loud. Then keep it boring on purpose. The owner who calmly says, "Here's the approval the board signed back in March" wins. The one who storms in furious and personal hands the board an easy reason to say no. You're not there to vent, you're there to make the fine look indefensible. Defenses come in 2 flavors, and the procedural ones are often your best friends, because they don't even require you to be right about the underlying rule. If the board didn't give you the notice or the hearing the statute demands, the fine can collapse on that alone. If the rule they're citing was never properly voted in or recorded in the governing documents, it may not be enforceable against anyone in the neighborhood, let alone you. And selective enforcement is the classic. If 3 other houses on your street fly the same flag, keep the same shed, or park the same truck, and only you got fined, that inconsistency is a genuine defense. But here's the catch. You have to prove it. A dated photo of the neighbor's identical violation is worth more than any heartfelt speech about fairness. Now the substance side. Start with the amount because boards get this wrong constantly. Many states tie their hands to a published fine schedule and a hard ceiling. In Florida, for example, a fine generally can't top $100 per violation or $1,000 in total unless your documents say otherwise. And in California, it can't exceed the schedule the HOA handed out. If your fine blew past that, it's overreach on its face. Second, and this one wins cleanly, if the board already approved the very thing they're now fining you for, say you've got signed architectural approval for that fence, then there was no violation at all, and no violation means no fine. And third, a rule or a penalty that's just plain unreasonable is vulnerable, because the law in most states only backs reasonable enforcement, not a board on a power trip. Run your eyes down the left column and a pattern jumps out. Every winning argument is about the board's conduct or the documents, something you can prove with paper. Now the right column. Every losing argument is about your feelings or your wallet. I didn't know the rule existed, won't save you. Ignorance of a recorded covenant just isn't a defense. My neighbor is worse, does nothing on its own. It only becomes selective enforcement when you back it with a dated photo. And I can't afford it is a real hardship, but it's not a legal reason the fine is invalid. Raise that separately as a request for a payment plan, not as your defense. So here's the filter. Take whatever you were about to argue and ask, can I prove this with a document? If you can't, it belongs in the right-hand column and you leave it at home. Most lost fights aren't lost at the hearing, they're lost in the first 2 weeks. Ignoring the letter is the big one. Silence reads as agreement. The deadline slides by, and now you simply owe it. The sneaky one is paying to make it go away. If you cut the check without putting your dispute in writing first, you can be treated as having accepted the violation, and good luck clawing that back later. Missing the window to request your hearing is a self-inflicted wound. The calendar does not care how airtight your case is. And letting it get personal, firing off an angry email, calling a board member a little tyrant, hands them ammunition and loses you the room. Calm, written, on time. Honestly, that's the entire discipline. A denial isn't a dead end. It's the bottom of a ladder you climb one rung at a time, and skipping rungs can cost you. Start inside the HOA. Use every internal appeal your governing documents give you, because a mediator or a judge is going to ask whether you did. Next rung is mediation. In several states, it isn't even optional. Florida, for example, requires the parties to try pre-suit mediation for most covenant enforcement disputes before anyone is allowed to file in court. It's cheaper, it's faster, and it quietly ends a lot of these. Only then do you look outward to a state agency or the courthouse. And one honest caveat before you get there. What outward even means depends entirely on your state. Some have a dedicated HOA office, and some, as you're about to see, barely have anyone to call. There's a point where doing it all yourself stops being brave and starts being risky. If the fine is large, if there's a lien on your home, or if anyone has used the word foreclosure, stop and call an attorney. The cost of one consult is nothing next to the house. Same goes if the enforcement smells like discrimination or retaliation for speaking up at a meeting. Those are legal claims, not hearing room arguments. And manage your expectations about the state complaint everyone pictures, because it varies wildly. A handful of states have a real HOA regulator with teeth, but many don't. Florida openly says that no government agency has the authority to investigate most complaints against your HOA. So find out what your state actually offers before you pin your whole plan on filing a form. So carry these out with you. First, reframe the whole thing. A fine is an accusation the board has to prove, and you are fully allowed to make them prove it. Second, move fast and get organized. The exact rule, the notice, the deadline, the hearing request in that order on the calendar, not in your head. Third, fight where you can actually win, which is almost always on process and paper. Improper notice, a rule that isn't really on the books, a fine over the cap, an approval you already had, never on how unfair the whole thing feels. And last, if the board digs in, climb the ladder in order. Their appeal, then mediation, then whatever your state offers, then a lawyer. Do that, and you go from a homeowner rattled by a scary letter to one who knows the rules better than the board that sent it. This video is general education, not legal advice, and the rules around HOA fines, the notice you're owed, the deadlines, the caps, and where you can escalate vary by your state and by your community's own governing documents. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and reviewed by a human against the cited sources before publishing. Before you act, read your own CC and Rs and bylaws. Check your state's HOA statute. And if the fine is large or a lien or foreclosure is on the table, talk to a licensed attorney in your state.